File AP-2502, AD-2431, and I'd like to start with the Pledge of Allegiance, please. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, so again, this is a planning hearing / appeal hearing. Once again, in regards to file AP 2502, AD-2431, and it's regarding an RV park development. So before we get started, I do have to recuse myself from this meeting. I'll run the meeting and conduct the meeting. I'm not allowed to take action, discuss, or vote, as I am a neighbor in this neighborhood, and it is an actual conflict of interest for me to participate in this. So what I would like to do is I would like to turn this over to our county planner, Zach Moody, to give us the staff report.
Thank you. So as you mentioned, this is a application for an appeal of file AD 2431 for an RV park located on Wedderburn Loop. The application, the date the notice of appeal was mailed on this application was June 25th, 2025. Of course, the hearing date is today. So since the appeal was received, we sent the notice out for public comment. We received notice through today. As a matter of fact, you should all have the last one that was included, which was sent by email at 12:30 this afternoon. There are a number of comments that staff had on the public comments that were submitted, as well as comments provided by the applicant's attorney. And first and foremost, the issue of standing needs to be resolved by the commissioners before the hearing continues. So in your packet, staff's comments provided show that there was a question of whether or not the appellant has standing in the hearing. And as such, the Planning Commission needs to make a determination that they in fact have standing in the appeal process, or the hearing does not continue. So with that, both staff and the applicant's attorney provided the appropriate reference of the Curry County Zoning Code, which states that the applicant must have made comment on the application to make themselves party to an appeal. In this case, the applicant did not provide public comment during the notice period, and such staff believes that the appellant does not have standing in the appeal, and therefore the hearing should be not opened. So with that, I did cite that information. It's in your additional information. It's also passed out to the public for their review. Specifically, section CCZO 2.0651 states that an administrative permit authorized by the director may be appealed to the Planning Commission pursuant to the following. Who may have appeal? The following persons have standing in the appeal. It's the applicant or owner of the subject property, any person who is entitled to written notice of the decision pursuant to this section, and any other person who participated in the proceedings by submitting written comment on the application to the county by the deadline specified in section 2.0635. In regards to any person who is entitled to written notice, since the appellant did not comment on the original application, staff believes that they were not, they were not entitled to written notice of the decision. They said that they were not entitled to written notice of the decision. They did not provide public comment on the original application, with their explanation being that they didn't receive a notice. Staff has provided in the record where the applicant, or excuse me, the appellant, Diane Powell, did receive notice on January 27th of 2025, and did not provide comment on the application during the public comment period. So with that, staff is asking for the Planning Commission to determine whether or not the appellant has standing in this application, or in this appeal.
Jay or Ted, do you have any comments regarding the staff report and what Zach just covered in regards to the appellate or closing of the hearing?
This is Ted Fitzgerald, and my position is that county code should be followed, and that as described herein, the appellant does not have standing as was just communicated.
Jay, did you want to add anything before I jump in?
Yeah, go ahead, Jay.
Sorry, is that Commissioner Coker talking?
Yeah, he was just about to get started talking, but go ahead.
I'll let him talk. I asked him to actually turn on his microphone because I couldn't hear him. Maybe it's not on yet.
Is your microphone on?
Jay, can you hear me?
I can hear you softly now.
Okay.
I concur with Director Fitzgerald and staff on this in terms of process. Right? If we choose not to follow the process, then we've created an exemption of the process, which now means we need to discuss whether or not we change the process in the future, which I'm not prepared to do. It sounds like the process itself is a sound process and in place to be followed. So I would have to hear a very, very compelling argument as to otherwise why we would forego our own policies in this matter.
Go ahead, Lynn.
So Jay, I'm going to concur with you and with Ted relative to the nature of the policy and the longstanding quality of the policy. I'm not here to change that policy, but I do recognize that there are implications for the people that have attempted to make comments, and having reviewed the comments that have come in so far relative to the process, I don't see a window of opportunity to go forward when it's so clear that the process is what the process is at this point.
So we do have a few public comment cards, and there's Tabitha has her hand up for comment right now. What's the movement for moving forward with public comment?
Commissioner Hollinger, I think the only issue is that we have to process on this, but if the hearing is not open, then we will not be having a meeting, which then would consist of no need for public comment on a non-existent hearing. That's just my take on that portion of the process. But you're running it, so.
Okay.
Well, that would be my position as well as counsel. I mean, if there's standing, then we don't move forward with an action.
I consulted county staff about this standing issue before going through any of this process. So I think that is, if we're following the zoning code and the ordinances in it, there are several reasons to have this hearing. And I would have appreciated that advice not being a public hearing notice being issued.
Hold on one second. Are you able to hear this at all? I'm sorry.
Yeah, I am.
You
I'm
can.
not sure why we're hearing it.
Okay. Well, I can't vote or anything along those lines. So
I think
Is
you
there,
need to call the question.
yeah.
You need to call the question for standing.
That
Okay.
should have been determined before a public hearing was.
I'm sorry. I can't reply. Okay, then would someone then like to make a motion?
I would move that we go ahead and deny standing. And is there a particular form that you've got?
No, the code does not prescribe anything,
Okay.
except for if the commission votes to deny the standing, that the hearing just does not open.
I so move.
Okay, I have a motion from Commissioner Coker. Do I have a second?
Sorry, I was on mute. Yes, second.
Okay, so I will call the question. Commissioner Coker,
Aye.
Commissioner Trost,
Aye.
and I recuse myself. So motion passes 2-0, and we will close this hearing.